God save the United States and this honorable court.
Okay. I don't see the lawyers yet, Mr. Huron, but if you will call the case, please, and we're ready to go.
Good morning, counsel. Good morning, judges. The first case this morning is 19-2197, Allen Jr. versus Environmental Restoration. Counsel, if you would please turn on your mics and cameras and please prepare to argue.
I apologize, but it's saying that my video is stopped by the host. There we go.
All right, good. We're ready to hear you, counsel.
Good morning, your honors. May it please the court. My name is Rory Miller. I represent the Appellant Environmental Restoration, LLC.
Mr. Miller, do you have a code handy?
Yes, hold on, I'm sorry.
Thank you, no problem. Thank you. We're informal, Mr. Miller, but not quite that informal.
I apologize. It's the seated position that really did me in, Your Honor. Now, to continue, the case that's on appeal deals with whether or not the Supreme Court's decision in International Paper Company versus Ouellette means what the Supreme Court said it means. And interestingly, this case presents an opportunity to see the value of a dissent other than simply an opportunity for a justice to express disagreement with the majority. In this case, the partial dissents by Justices Stevens and Brennan demonstrate that environmental restoration's interpretation of international paper as requiring the point source rule under the Clean Water Act to apply to all laws, not simply substantive laws, and displace any of the forum states rules, including conflict of laws, is correct. We see this because Justice Brennan's dissent is exactly what the district court did in this case. Justice Brennan urged that instead of what the Supreme Court majority did, a traditional conflict of law analysis be applied. That is not what the Clean Water Act requires. As the Supreme Court announced in international paper and made clear in its subsequent decision of Arkansas versus Oklahoma, the Clean Water Act displaces all traditional common law choice of law and all forum state choice of law in favor of the application solely of the law of the state in which the source of the alleged pollution occurred.
Now, counsel, in fairness, the limitations issue was not present in international paper, was it?
No, there was not a statute of limitations issue in international paper. That was entirely on choice of law writ large. However, the Supreme Court is fully capable of drawing whatever distinctions it wishes. It didn't say this is the substantive law of the state of Vermont. It didn't say only the substantive law of Vermont. It said the law of Vermont.
But don't we generally presume that they're only addressing the issues before them, which in that case had to do with substantive law as opposed to procedural law?
One would generally presume that, Your Honor. However, that's again where the dissents become very helpful to us. In the dissent by Justice Stevens, actually, he criticizes the majority for going above and beyond the narrow issue presented to it and making a sweeping generalization regarding the displacement of the forum states' laws. And we see that this, in fact, is the meaning because Justice Stevens himself, who was critical of this expansive reading in international paper, authored the unanimous decision in Arkansas versus Oklahoma, which held that, and I quote, the only state law applicable to interstate discharge is the law of the state in which the point source is located. So while he was critical of the majority's decision to go beyond the narrow issue that was presented, he was not challenging its authority to do so. It's well known that the Supreme Court has the authority to pass on however narrow or broad an issue as it wants that's presented to it. It elected to do so in that case against the prudential urgings of Justice Stevens, but he did not challenge its ability to do so. And in fact, when given the opportunity, writing for the majority of the unanimous court in Arkansas versus Oklahoma, did not take any steps to limit it or identify a disagreement with the earlier holding other than on that procedural basis, which he had previously identified and did not bring up again. So yes, while normally we assume that the court is making as narrow a ruling as possible, here, by the nature of its dissents and the fact that that dissent was not objected to or the majority opinion was not modified in response to, it's clear that in fact, in this instance, the Supreme Court did intend to announce a categorical rule in the international paper. And as the entire unanimous Supreme Court reaffirmed a few years later in the Arkansas decision. So again, while that would be the normal presumption, that is not the case here. Much like, for example, the normal presumption is that the standard rules of conflict of laws apply to an analysis, unless otherwise displaced by statute. Here, the Clean Water Act was designed to be a comprehensive regulatory program by Congress that displaced in its entirety the earlier patchwork of sporadic and ad hoc approaches to the law.
Doesn't that counsel in favor of the 5-year limitations period, so you would have a uniform nationwide limitations period?
Sometimes it would. However, again, the decision made by Congress was that the point source's state law apply. And the issue there was whether or not there was predictability for a regulated entity. The Congress recognized in passing the Clean Water Act the primary position of a point source state in regulating conduct within it. Here, the addition of a 5-year statute of limitations actually would counsel against that deference to state courts and state law. And the reason for that is twofold. One, the scope of a substantive right, tort liability, is affected by the scope of the limitations. And it's a general principle of law that courts should not expand the remedies available under a state court's laws by virtue of a statute of limitations. That's one of the reasons why the federal general catch-all does not apply.
So
secondly,
if we were to apply the federal general statute of limitations, we would be applying a federal statute of limitations to state law, a state law claim.
That's correct, Your Honor. This is a state law tort claim that's at issue here. And so to apply the federal statute of limitations would be applying a federal statute of limitations to a state tort claim. The question here is really whether a specific act of Congress, the Clean Water Act, displaces traditional conflict of laws analyses by a district court sitting in diversity. Here it does.
One of the things that I am questioning is why you're fighting so hard not to do choice of law analysis for the statute of limitations, because under Colorado choice of law statute, it looks to me like it would be Colorado's shorter statute of limitations because the substantive law is Colorado. Am I missing something there?
You're not, Your Honor. However, that was not the conclusion reached by the district court. And the issue here, because this is an interlocutory appeal, not one after the full procedure, is whether or not the district court's analysis of the choice of law was correct. So we don't believe that the court even needs to get to that issue because choice of law has been displaced by the Clean Water Act and the point source rule.
And you're relying on footnote 20 of the Supreme Court's decision in Appellant, talking about choice of law?
Yes, and generally the point source rule as a whole, and the Supreme Court throughout its decision in International Paper versus Vette and its subsequent decision in Arkansas versus Oklahoma, continuously and consistently used categorical language that the point source rule applies the law of the source state and displaces any statutory or common law of downstream states. In this case, for example, New Mexico. Now, one thing that I'm sure is in the back of everyone's minds, although not technically applicable to interpretation of the Supreme Court precedent, is whether this reaches a just result. And the answer to that is yes, even though it requires or would require dismissal of the plaintiff's claims in this case as time barred. The reason for that is because although here the point source rule would impose a narrower statute of limitations than the forum states rules, this is not a rule that is inherently favorable to one side or the other. For example, what if the point source were New Mexico with a 3-year statute of limitations and the forum state were Colorado with the 2? The opposite of what we have here. The international paper decision would require the application of the longer statute of limitations in that case, because that is the law of the point source state. Inherently tied in this jurisprudence is the substantive rights and the procedural limitations upon those rights, including statutes of limitations. This has the additional benefit of avoiding jockeying or lobbying for forums for multi-district litigation, such as the current case. The current case is one of several that have been consolidated into New Mexico for MDL administration. And that was done despite the fact that there were a number of other forums. There could have been this case sent to Colorado District Court. Utah, the state of Utah has claims. Its district courts may have also had jurisdiction. Rather than have a fight where one side or another seeks to gain a litigation advantage by choice of law provisions or where the multi-district panel chooses to assign a case for consolidation, the application of the point source rule and the proper application of the Supreme Court's precedent in international paper eliminates that need. There is easy predictability. Wherever the source of alleged water pollution exists, that state's tort law governs any claims that may exist for downstream plaintiffs, and that state's statute of limitations governs that, so that there is clear, consistent, and understandable rules rather than the ad hoc patchwork that was swept away in the city of Milwaukee versus Illinois and Michigan case by the Supreme Court in 1981. With that, I have about 3 minutes left I'd like to reserve for rebuttal unless the court has other questions at this time.
They're reserved. Thank you. Counsel, we're ready to hear you as well.
Good morning, Your Honors. My name is Kate Furlick. I represent the Allen plaintiffs, the appellees in this case, who are a large group of Navajo farmers and ranchers that were damaged by the Gold King mine spill. May it please the court.
Why shouldn't we apply a point source law generally to start looking at this problem?
Because, Your Honor, uniformly, the courts have concluded that a forum state's application of its own statute of limitation governs.
So just following that through, if there are damages downstream to 3 other residents of 3 other states, and those 3 states all have a different statute of limitations, would the statute of limitation of the tort state, that is where the injury occurred, differ for all 3 sets of claimants?
Your Honor, the application of substantive law would not under OLEA.
No, I understand. That's not, we don't have a question of substantive law here. Let's get to the procedural question, which statute of limitations. And my question is, for example, point states A, B, and C each have a different statute of limitation. Would we apply the statute of limitations for the residents of each of those respective states? And whereas, for example, state residents of state A's claim may survive, B's would not, C would not, as an example.
Yes, Your Honor. Well, potentially, because ultimately it is the forum state's procedural law that applies when sitting in diversity jurisdiction.
And if the multi-district panel chose state B where the statute had expired, would then it have expired for everybody else, even though the law in state A would have allowed it?
Potentially, it would depend on the laws.
What do you mean, actually? I mean,
well, for example, under Colorado has a borrowing statute. You know, the Colorado courts sitting in diversity would go through the same analysis that New Mexico goes through. What is interesting and noteworthy is the appellant here is the party that moved to consolidate in New Mexico. And in the motion to consolidate, which was filed about 2 years and 2 months after the Colorado 2-year statute of limitations, they acknowledge that there are other claims that are going to be filed by the folks that preserved their administrative claims with the EPA, and that is the Navajo farmers and ranchers. So the appellant here, elected and in fact urged the case to be consolidated in the District of New Mexico.
I don't really see how that impacts what the answer here is as a question of law. And I can't get over the Supreme Court and Appellants quoting with approval the statement from Milwaukee 3 that dischargers would be forced to meet not only the statutory limitations of all states potentially affected by their discharges, but also the common law standards developed through the case law of those states, and saying that would be unacceptable under the purposes of the Clean Water Act state action rule. I think the Supreme Court's told us the answer here.
Well, Judge McHugh, I think that would point to an argument for a federal statute of limitations. But
no, because a federal statute of limitations very clearly applies when federal Congress adopts a federal law and does not put a statute of limitations in it. What we're dealing with here is state tort law. So I don't see any application of the federal general statute of limitations at all.
Well, and I understand that. And I agree that a forum state's procedural rules should apply, and they should go through their own choice of law analysis depending on where the forum is. But Ouliette expressly does not go as far as appellant argues, not even close. I mean, Arkansas Justice Stevens, despite Mr. Miller's representation that he doesn't limit Ouliette in any way, in fact does. And Stevens is writing for unanimous court and expressly states that our statement in Ouliette concerned only an affected state's input into the permit process. And in his concurrence in the case, he also, I think the appellant misrepresents the argument here. He acknowledges that it's only a substantive law that applies to the Clean Water Act, because a procedural law like the statute of limitations doesn't frustrate the purpose of the Clean Water Act, which is, in summary, to protect the nation's waters, but more specifically to administer a permitting process. And that's why the substantive law applies. The states under the Clean Water Act are acting as the federal government in issuing permits through these EPA administered programs. It's just that downstream states or those impacted can't all of a sudden decide to impose higher water quality standards because that substantive state law requires different standards. I mean, Ouliette in no way, shape, or form upends an entire, 200-year history of choice of law analysis. And in fact, in Ouliette, international paper urges the court to say that venue must be brought in the point source state. And the court refuses to do that. And it would make sense if they were going to extend the procedural law of the, whatever the point source state is, to say, let it be venued then in the point source state, because that court is most adept at applying its own procedural rules. And, this is well articulated in the Anderson case, the Anderson Living Trust case, just the idea of the enormous burden of a forum state having to apply the procedural rules of another state. And where does this end, judges? I mean, does this extend to rules of discovery, process, service? I mean, it just absolutely is incongruent with 200 years of law.
Let's go to some classic tort analysis here. Let's say a car is speeding from Colorado into New Mexico at a rate in excess of the speed limit of both states. And as a matter of law, then is negligent. He fails to apply his brakes. The driver fails to apply his brakes in Colorado, but hits somebody in New Mexico. Where did the tort occur? The actionable tort occur?
So say that again. That
takes too much time to state that again. I mean, if you could figure out the question, answer it. If you can't, we'll go on to something else.
Well, the forum state, the state where the plaintiff sues, performs its own choice of law analysis and decides which substantive law to apply. And in New Mexico, which follows the first restatement of torts, it would be where the injury occurred, and that would be defined as the last act to complete the injury. And so it's very possible that New Mexico would apply Colorado substantive law in that case, but it would still follow its own procedures. And this is, well established in Sun Oil, in this circuit's own decisions in Burnham.
I would have thought that your answer would have been New Mexico, because that is the sine qua non of the tort. That's where the injury occurred. And
I'm sorry, I thought you said Colorado.
I guess sometimes my questions don't go through. I said, in what state did the tort occur was the question.
And where was the accident?
Thank you. That's really quite all right.
Right, I'm sorry about that.
Let's go on to something else because I'm wasting your time, and I don't.
Okay, let me interrupt. As I understand what the Supreme Court and Congress are doing, in focusing on the source of the release, the state in which the environmental release happened, is that you have an analog of the federal court sort of sitting in diversity, but the idea is the result, no matter where you bring it in an affected state, should be the same result you would get in the source state. And here, what you want is a result that could never happen in the source state because your action is barred. Isn't that a problem for the overall goals of the statute here in terms of how it's designed?
Your Honor, not at all. And the reason is that a forum state always applies its procedural rules. And
it doesn't always if Congress has preempted it and put in a different procedure. And, so to wave around a bunch of procedure versus substantive cases that have to do with traditional diversity cases doesn't really help us with this analysis. So I'd like you to focus on the statute we're dealing with and its goals and purposes.
Understood, Your Honor. The Clean Water Act is obviously silent on any sort of statute of limitations, but applying a forum state's procedural rules does not frustrate the purpose of the Clean Water Act in any way. And there has been no argument made, no colorable argument that it would in fact do this. The Clean Water Act deals with a permit system. And
there's two things. The Nepotes side of the Clean Water Act deals with a permitting system. And there's a balance between the affected state and the source state in terms of how much input they have in setting the limits on the Nepotes permit. But then you have another section of the Clean Water Act that allows for state tort actions based on damage caused to people for releases. And so they're not necessarily the same, and the statute spreads the authority between affected states and source states with a lot more power in the source state, even on the permit side.
Understood. And that is clearly to meet the goals of predictability in terms of substantive law. The point source state is the regulating entity for the discharger, no matter where it's coming from. And so not only do the quality standards apply, but under ULET, the tort law of that state applies. But the substantive tort law is different than the procedural law of a forum state. And I think citing all of those diversity cases where courts sit in diversity cases is just simply the long-standing principle of American jurisprudence, that this happens all the time. And there's no affirmative argument that somehow the Clean Water Act preempts this, or that ULET intends to sweep away the procedural rules. I'd like to point the court to cases that interpret OLIET or international paper. And those cases, and particularly the Kaufman case, Ashland Oil v. Kaufman, addresses the exact issue before this body. And that is, they don't get to the question of substantive law, but regardless whether the substantive law of the point source state applies, the procedural law, including the statute of limitations of the forum state, applies. And it's also interesting that, in terms of federal preemption, I think that if this court does believe that there is some kind of federal preemption, that the standard federal statute of limitations should apply. In the Ninth Circuit, that's what they're doing in order to resolve these questions. And there was just a recent case decided on that, but we cite the majority of the cases in the brief. But in no way, shape, or form do any of the progeny cases of OLIET or does OLIET stand for the proposition that the Clean Water Act requires that a state's procedural law needs to be applied according to the source state.
Thank you, counsel.
Thank you, Your Honors.
Your Honors, I just have three very brief points that I'd like to highlight that I think respond to opposing counsel's arguments. First, the issue of how far do we go with procedure is, I believe, a red herring in this instance. We're discussing the statute of limitations, which is so bound up with the right of remedy that the law affords that it really is not the same as a rule of discovery. Procedural rules that make it more difficult to bring a claim are frequently upheld and imposed by federal courts. And statute of limitations that define the scope of a substantive right is one such thing. We cited some cases for that in our reply brief on page 8, but those include the Guarantee Trust Co. versus New York and Racher versus Westlake Nursing Home partnership case out of the 10th Circuit. In fact, that case specifically said this includes the applicable burdens, defenses, and limitations, Your Honors. Second, the issue of what Justice Stevens meant as he was writing the Arkansas case, whether I was misquoting it or not is up to Your Honors to decide. However, I would like to read one small bit of it. This is a quote from page 100 of that decision. The Clean Water Act, taken as a whole, its purposes and its history, preempted an action based on the law of the effective state, and that the only state law applicable to an interstate discharge is the law of the state in which the point source is located. The only law of the state is what Justice Stevens wrote for a unanimous court. Finally,
but that begs Judge Carson's question. which is, I think, very tightly focused on that. And that issue of statute of limitations was not even before the Supreme Court. And so what you're asking us to do is throw out all the Erie and post-Erie jurisprudence on all of these related issues and just go on a hope and a prayer on some theory that substantive preemption somehow includes procedural preemption. I'm not sure that I ever heard the answer to Judge Carson's seminal question, because that is the issue for us to consider here.
That's correct. And I'm not asking the court to go on a hope and a prayer. Congress has instructed the courts to do so in its passage of the Clean Water Act, which, to quote the Deepwater Horizon case out of the Fifth Circuit, Congress could and did supplant federal common law with an overarching regulatory framework to protect the nation's interests. And then to quote the Fourth Circuit, applying international paper to, I'm about to run out of time. May I have this quote before I finish, Your Honors?
Well, I think we'll read the quote, and thank you very much for your arguments, both of you. They're very well presented. Thank you. The court is, the counsel are excused and the case is submitted.
Thank you, Your Honors.
Mr. Harone, if you'll call the next case, please.
Yes, Judge. The next case this morning is 20-1105, Janny versus Gamez.
May it please the court, Charles Wayne for Appellant Mark Janny. There is no question that the government may not force a choice between going to church or going to jail, if that's what happened here. Mr. Janny, an atheist, spent 150 days in jail for refusing to participate in Christian worship while on parole. The court should reverse the decision below for three reasons. First, the district court erred in granting summary judgment when it disregarded competent admissible evidence of violations of both the Establishment Clause and the Free Exercise Clause. Second, the court erred when it ruled that the Colorado parole officer, Appellant Gamez, was entitled to qualified immunity. And third, the court erred when it ruled that the operators of the private religious program, Appellees Carmack and Constantine, did not act under color of law. With regard to the Establishment Clause claim.
Let me just, what evidence did you put forward of Mr. Constantine's involvement with the state and knowledge of the relationship between Carmack and Mr. Gamez?
Well, Judge McHugh, the following evidence was presented by Mr. Janny below. First, Mr. Constantine was present for that February 4th, 2015 telephone call that he was there and Mr. Carmack was there, and they were speaking to Mr. Gamez about Mr. Janny's refusal to participate in the religious program. Mr. Constantine, even though he claims he didn't speak during the call, was in fact aware of what was said, and that's in the record. Second.
And that's enough for him to be a state actor?
There's more, Your Honor. As Mr. Janny stated in his verified complaint and his two sworn declarations, Mr. Constantine, like the other two appellees, said to him, "You're going to do the program or go to jail," repeatedly. Moreover, Mr. Constantine proselytized Mr. Janny. He conducted the two Bible classes that Mr. Janny was forced to attend. Moreover, Mr. Constantine reprimanded Mr. Janny for skipping morning prayers in chapel.
Is there any evidence that Mr. Constantine said, if you skip chapel, I'm going to make you go back to jail?
Yes,
that
there is.
Said
You're
that?
going. I'm sorry?
That he said that? Or
Mr.
that he was in a room when somebody else said it?
No, Mr. Janny's sworn statement is that both Mr. Constantine and Mr. Carmack said to him on separate occasions repeatedly, "You're going to do the program," meaning participate in religious services, "or go to jail." And that's in the first volume of the appendix, page 166, Mr. Janny's deposition, page 73. So then, in fact, there is evidence that Mr. Constantine said that very thing.
Okay, so say he said it. He couldn't make him go back to jail. What if he didn't have that authority?
Well, between the three of them, they all did, in fact, if not authority, the three of them had the ability to do so, because Mr. Janny was expelled from the program, expelled from the rescue mission, which was his required place of residence under the parole directive. As soon as that happened, Mr. Gamez was notified because Mr. Janny's electronic monitoring device was unplugged, or the parole office was notified. Mr. Gamez had an arrest warrant issued, Mr. Janny was arrested, and Mr. Janny was sent back to jail for an additional 150 days. As a direct result of his refusal to participate in the Christian worship and other religious activities at the program.
So you don't disagree that the mission can, kick people out of the mission for not participating in the Christian activities, do you?
No, we don't disagree with that.
In the state, and you don't have any allegation that the state of Colorado controlled the rules up at the mission, do you?
We do have no evidence of that, but the content of the program is the precise content. The fact that the state did not design the content of the program is, as both the Seventh Circuit and the Ninth Circuit have ruled in the cases we've cited to the court, that's of no moment, because the state knew of the content of the program and required, in this case, the parolee to participate. The fact that they didn't design it doesn't matter.
But how does that go to Carmack and Constantine? That goes to your other defendant.
That's correct. That goes to the parole officer.
Okay.
Well, with regard to Carmack and Constantine, they agree and they admit on page 16 of their brief that there was a religious component to the program. That was the whole point of it. What they say is it really doesn't matter because we're private citizens and there's no state action. That goes to the state action point, and I'll address that now if Your Honor would like.
Well, let me ask you.
They're right, aren't they? If there's no state action, then they can have a religious content all they want and they can kick people out if they don't comply. So without state action, you admit you don't have a claim, right?
Against the two, what we call the program defendants, Carmack and Constantine, that's correct. State action is required. And we have argued there, as Your Honors know, there are 4 separate tests for state action. Our position is the evidence set forth below satisfies 2 of them, both the joint action test and the nexus test. And we did brief that, and I'm happy to address that issue now if Your Honors would like.
Well, let me ask you a couple more questions. You don't contend that the mission's being paid by the state for having your client there, right?
That's correct. That's not in the record.
And there was no contractual agreement between the state and the mission for having your client there?
There was not. There was an informal arrangement between parole officer Gamez and Mr. Carmack, who was a former parolee of Mr. Gamez.
Okay.
That's how the parolees, and in fact, as is in the record, previously only female parolees had participated in the program sent there by Mr. Gamez. Mr. Janny was the first, and Mr. Carmack told him, "You're a guinea pig, and you're the first, and the plan is to expand this to include male parolees."
Okay, well, maybe, how does that turn it into state action, though? Maybe as part of their mission, they want to help people who are on parole, who are otherwise shut out from housing.
They may want that, but it's up to the state to provide a secular option. No secular option was provided to Mr. Janny.
Well, they didn't have to take him. I mean, they offered a place, the states who made the decision that he could be placed there, not them.
Your Honor's question goes to whether or not the evidence below satisfies the state action standard. And as the court knows, and as the court has held, the issue is the relation between a nominally private party and the alleged violation close enough so that the private party may be considered a state entity under Section 1983, and that both the joint action test and the nexus test are satisfied here. And they were satisfied here because, first of all, with regard to the joint action test, there was this informal arrangement, number one. Number two, when Mr. Janny, an atheist, objected to the required Christian worship, that resulted in threats of jail from all three appellees, including the private appellees. There was this phone call during Mr. Janny's orientation on February 4th, 2015. There was a parole office meeting that Mr. Carmack drove Mr. Janny to and attended. And importantly, at that parole office meeting, among the things that happened was Mr. Carmack, as promised to Mr. Janny, asked Mr. Gamez to change Mr. Janny's curfew from 6 o'clock in the afternoon to 4:30, so Mr. Janny would be present for evening prayers.
Where is that in the record that Mr. Carmack asked that it be changed? Because as I read it, he didn't ask that it be changed. He said he was going to be required to attend every night, and that it was the parole officer's decision to change the curfew, that there was no explicit ask on the curfew.
No, there was in fact an explicit ask, Your Honor. And I would certainly cite it in our brief. 1 second. I don't have the precise site, but it is in our brief. And there was a specific, the facts are these. At the orientation session the morning of February 4th, Mr. Carmack said to Mr. Janny, I'm going to request that your curfew be changed from 6 o'clock to 4:30. They went to the meeting with Mr. Gamez that afternoon. He asked that it be changed. Mr. Gamez did in fact change it, and that's reflected in documentary evidence on the electronic log that recorded every event with regard to Mr. Janny's parole, and his curfew was changed that very day from 6 o'clock to 4:30. So there was an ask and there was an agreement, and it was done.
And I see that as to Mr. Carmack, but I'm not seeing in the record that Mr. Constanti did anything other than his job. And I don't see anything where he told your client that if he didn't go participate in the religious services, he would go back to jail. And I'm going to check. You gave me volume 1, page 166, his depo at page 73, and I will read it again. But that's my problem with state action is Mr. Constanti.
Well, I understand your Honor's point, but that certainly is part of it. But there is also evidence, as I mentioned before, both of the proselytization and also the fact that it was Mr. Constanti who conducted the Bible studies that Mr. Janny was forced to attend.
But that, if I happen to be a minister in a church and I'm proselytizing and I'm putting on religious services and somebody else with state authority makes somebody come to my services, that doesn't make me liable under 1983.
Well, it does if there's joint action between the state official
and me, not
correct.
Somebody else, me.
Agreed. And in fact, we say that there was in fact joint action, both in that telephone call placed during the orientation and Mr. Constanti's later conduct having to do with the we've cited, Your Honor, to the deposition. Obviously under oath. In addition, the declarations, both the original one and the amended one, also under oath, state that Mr. Constanti reprimanded Mr. Janny for skipping morning prayers in chapel. And as I said before, with regard to both of the Bible studies.
Don't want to interrupt, but I think you wanted to reserve some time.
I did, Your Honor. Thank you so much.
All right. You might. Okay. Thanks. Counsel.
Good morning. Before we begin, I just wanted to point out for the court that Mr. Lebsack and I are going to be splitting our time. So I'll take about the first 9 minutes or so. I will discuss the claims against Officer Gamez, and Mr. Lebsack will speak specifically about the state action.
That's fine. Just be careful of your time, and cooperate with it. Thank you.
May it please the court, my name is Gregory Bueno, and I represent the defendant appellee, Officer John Gamez. Your Honors, the arguments presented by Mr. Janny make the case quite a bit more complicated than it really is. It ultimately is very simple, at least as far as the claims against Officer Gamez are concerned. And there are three key facts in this case under which this court should affirm summary judgment in favor of Officer Gamez.
And
first,
do all of those require us to ignore the sworn statements of Mr. Janny?
Well, the sworn statements by Mr. Janny, and I assume that means the deposition testimony, anything that he submitted in support of the motion for summary judgment.
And
in that particular case.
And his verified complaint.
Understood.
Our case law says can be treated like a declaration for purposes of summary judgment.
Understood. So in that particular case, there are a number of statements that Mr. Janny makes, which really form the basis of his case. That case is not established anywhere else in the record. And broadly speaking, our position has been and continues to be that that explanation that he gives about the circumstances under which he was housed in the Denver Rescue Mission and the circumstances under which he left the Denver Rescue Mission, all of that is essentially a post hoc rationalization, a post hoc explanation of what happened. There is not anything in the documentary record which even remotely squares away with that explanation. You have these CWIS logs that are extensive. They record every single interaction between a parolee and a parole officer or anyone at the parole board. And if there had been any sort of interaction, any discussion about being compelled to attend or participate in religious in religious programming, if there were any issues that Mr. Janny was trying to communicate with regard to that, that absolutely would have been somewhere in the documentary record. So ultimately,
well, that's an argument for the jury that says you should believe what we're telling you over what Mr. Janny is telling you, but it doesn't allow the district court to discount the evidence put forward by Mr. Janny. And frankly, the probation log entry of case management meeting on the afternoon of February 4th followed immediately by an entry changing Mr. Janny's curfew to 4:30 p.m. supports Mr. Janny's allegations of what happened at that meeting. So you can read that log either way, which is why we don't just ignore sworn testimony at this stage.
Well, in this particular case, the evidence, again, that is presented by Mr. Janny is ultimately, it is simply not in any way corroborated by, I'm sorry?
It's not persuasive to you.
Well, it's not a matter of whether it's persuasive. I mean, there is case law that states when a litigant's statements in support of a motion for summary judgment are blatantly contradicted by the record such that no jury could believe it.
That's Scott
at that point,
Harris, and we have never applied that outside the context of video recordings or other irrefutable evidence. We've never applied it in a situation of a he said.
I understand what the court is saying, but there are a number of undisputed facts in this case which alone would be sufficient to affirm summary judgment. And I'm just going to go through them real quick. So to begin with, there's no dispute that Mr. Janny was arrested and ultimately found to have violated his parole contract because he did not remain at his residence of record every night, as he was required to do so by condition 2 of his parole contract. That's page 221 in the first volume of the appendix. In other words, he was found to have been in violation of his parole contract because he absconded, not because he violated the subsequently imposed condition that he was to abide by the rescue mission's house rules, which, by the way, were not, that order was not specific as to having to participate in any sort of religious programming. Secondly, there is no dispute that Officer Gamez's decision to require Mr. Janny to live at the Denver Rescue Mission was motivated by his belief, based on his expertise in supervising parolees, that he had to have been placed there because any of the other alternative residences would have not been conducive to him complying with his parole terms. And this was critical because if you look at the CWIS logs, there was a history of Mr. Janny not complying. He had absconded, he had failed to obey curfews on numerous instances, he had failed to communicate with his parole officer as he was required to do. And finally, it's also the case that while Mr. Janny was ordered to live at the mission, we're not disputing that the order came down, he was not being compelled to live there in perpetuity. The relationship between a parolee and a parole officer is, in fact, in many instances, it's collaborative. You can communicate, you can say, listen, I'm having an issue with what is going on at the Denver Rescue Mission. And in this particular case, it is unfathomable that if any of those conversations had actually taken place, that they would not have been in the CWIS logs. And if we apply these facts to the Establishment Clause claim and the Free Exercise Clause claim, we can affirm summary judgment. And with regards to the Establishment Clause claim, this is true regardless of whether we apply the Lemon test, which has been generally applied by the circuit in the past, or the Lee test, which Mr. Janny would like us to apply.
Isn't the Lee test the proper test here? We're dealing with a coercion allegation.
Well, the issue of whether, the outcome would be the same under either test. Is there a coercive component to what to the order that Mr. Janny live at the Denver Rescue Mission? Yes, I suppose there is, but that's neither here nor there because the result would be the same either way. So, for instance, to pass constitutional muster on the Lemon test, a government action has to have a secular purpose, right? The secular purpose of placing Mr. Janny in the Denver Rescue Mission was.
I think we're looking at the Lee test, and so we're looking at the 3 prongs of the Lee test here, aren't we?
Well, I'd be glad to address the Lee test for sure. So the Lee coercion analysis involves a 3-step inquiry according to Kerr versus Ferry, which is what Appellant's counsel cited to in his main brief. First, has the state acted? Second, does the action amount to coercion? Third, is the object of the coercion religious or secular? So the word object is key there. What is the true purpose of this of this order? And the order to have him live at the Denver Rescue Mission is to give him an appropriate place to live. Well, it is and because he had not provided an alternate place to live that would have been appropriate, that would have been conducive to him complying with parole, with checking in when he needs to, with making sure he stays out of trouble, which he had trouble doing in the past. And the same goes with the decision to ultimately find that he was in violation of parole. That was not the object of that decision was not religious. It was secular. It was because he, by all accounts, absconded. He left without permission.
But he can be properly in violation of parole and still have a valid claim under the Free Exercise Clause or the Establishment Clause, can he? They're not mutually exclusive.
No, they're not mutually exclusive, but he would still have to show that there was a religious rather than secular purpose for the decision. And in this particular case, whether you're talking about the placement or the removal, it was secular in nature because, and with regards to the removal, with the violation of parole, in that particular case, the secular purpose was the fact that he was not found to be in violation of parole because he didn't follow the rules, whatever that may be, which could have been attending or participating in religious activities.
But that's
in this particular case, it was because
for purposes of the Section 1983 Act, we're not looking at his parole was violated. We're saying his First Amendment right was violated.
Right, but I mean, I believe
making him participate in the program.
Right. Well, yes. It's not that his parole was violated. That's not but what he's saying is that his First Amendment right was threatened ultimately by being by having his parole violated. That is part of the claim. I think that's the distinction that Mr. Janny is trying to make. And I'm mindful of my time here, and I just wanted to make really quick remarks about the free exercise claim. So to To plausibly state a claim of religious discrimination, a plaintiff has to show evidence that the conduct complained of did not occur for a neutral reason, but for the purpose of discriminating on account of religion.
That's
the
only if
neutral
they're
reason here,
bringing a claim that is based on discrimination, but if they're bringing a coercion claim, they don't have to prove that under free exercise, do they?
Well, I guess that depends on how we are interpreting the claim. I mean, when we briefed it below, we briefed it as an intentional religious discrimination claim, and now it seems to have shifted a bit into a claim similar to Sherbert versus Werner. But again, in that particular case, we would just go back to point out that the documentation in the record is overwhelming, that what Mr. Janny had said about Officer Gamez's motivations for placing him in the Denver Rescue Mission, the conversations he had with the co-defendants, none of that is in any way played out by the documentary record. And if there are no further questions, I will yield the rest of my time to Mr. Lepsek.
Thank you. John?
May it please the court, my name is John Lebsack, and I represent defendants Carmack and Constanti, who were the employees of the Denver Rescue Mission. In the short time that I have left, I want to focus on a few key facts and then compare this case to the Gallagher versus Neil Young concert case to show the very close parallels in the legal issues between this case and that case. So the district court got it correct. There was no state action in this case. The referral by Mr. Gamez to the mission was for housing. It had no component of you must go there for religious instruction. The issue of the religious orientation did not come about until the day after Mr. Janny arrived at the mission. So as Mr. Gamez states in his affidavit, it's a standard procedure in every referral to require housing and to require following the house rules. So that's all that he did. So the rules that were set up by the mission were set up by them with no influence from the state. The state did not get involved in setting the rules. The mission set up the rules. So when Mr. Janny arrived, he was following rules that had been set up solely by the mission. The mission had no contract with the state. It didn't receive any compensation. So let's compare this case to the Gallagher case and the Neil Young concert. So in the Neil Young concert case, the state of Utah's university leased its arena. And in the lease was a requirement for appropriate security. And the concert promoter hired a security company, and the security company had a procedure to require pat-downs on admission to rock concerts. The university was aware of that. It was not part of the contract, but there was a meeting at the venue where a representative of the university was there and heard the plans for the pat-down. And the court, this circuit, correctly held that that was mere acquiescence. The fact that the university knew about the pat-downs did not mean that there was joint action, did not mean that there was nexus, didn't mean that there was state action under any test. So the court held in Gallagher that there was no state action. For the same reason, there's no state action here by either Mr. Carmack or Mr. Constanti. Judge McHugh, you're correct. Judge, the involvement of Mr. Constanti was very distant, but even looking at Mr. Carmack, there was no state action by him. It was the mission's own procedures. Mr. Gamez, the parole officer, was aware of them, but he didn't do anything other than acquiesce. The mission did not have the authority to expel anybody, to send somebody back to jail. I misspoke. They did have authority to expel, but they didn't have any authority to send anybody back to jail. So the state action of the decision to send him back to jail had nothing to do with what the mission did. So, the reference to the conversation about the setting the change in the curfew is in the record. May I give the site, Your Honor?
Thank you, Counsel. Oh, we're aware of your citations, Counsel. Okay. Thank you very much. We appreciate your time. Counsel, I believe you have a few minutes left. Just a couple of minutes.
I do. Quickly, with regard to Judge Carson's question about the curfew change and where that is in the record, Mr. Carmack said that he would ask Mr. Gamez to change the curfew. That's in volume 1 at pages 31 and 32. That's the complaint. Mr. Carmack did, in fact, ask that the curfew be changed. Again, that's volume 1, page 32. Also, volume 1, page 167, on page 83 of Mr. Janny's deposition. And in fact, Mr. Gamez did change the curfew, and that's volume 1, page 167, again, page 83 of the deposition, and it's also in the electronic log of the parole, which is volume 1, page 239. With regard to there were questions about the rules of the program by your honors. The parole directive stated that Mr. Janny was to abide by all house rules as established, and that a violation would mean jail. And that's in the parole directive itself. That's volume 1, page 251. In Mr. Janny's declaration, at volume 2, page 411, he says that Mr. Gamez said to him, "The rules of the program are the rules of your parole, including the religious ones." Then Mr. Gamez, at the February 4th meeting in the afternoon, the second meeting that day, said to Mr. Janny, "You must follow the rules of the program or go to jail." And again, that's volume 1, page 167 at page 83. With regard to counsel's citation of the Gallagher case, the Neil Young concert, we've distinguished that in our brief. In that case, there was no joint action between the state and the private parties. There is evidence of joint action here. I've talked about some of it already, and the rest is certainly set forth in detail in our brief. And I see that my time is almost up, so we will submit any issues that I did not reach on the brief.
Right. Thank you, counsel. Your time has expired. Mr. Liebeck, I didn't mean to cut you off on your citation. If you had a citation that's not in your brief, feel free to submit a letter to us with your proper citation. Thank you, counsel. Counselor.
Mr. Wayne already gave the citation, so I won't need to do anything.
All right, good enough. But if you do, feel free. I mean, we're always open for business. Thank you, counsel, for your arguments. Very well done. The case is submitted. Counsel are excused. The court will be in a 8-minute recess, and then we'll resume the remaining cases. Thank you.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Thank you, Mr. Harone. If you will be so kind as to call the next case, please.
Welcome back, counsel. The next case this morning is 20-1118, Vette versus Sanders.
Counsel, we're ready to hear you.
Good morning, and may it please the court. My name is Eden Rowland, appearing on behalf of the appellant, Sergeant Keith Sanders. I would like to reserve 3 minutes of my time for rebuttal. This appeal is about the district court's wrong application of the wrong legal standard on summary judgment when qualified immunity is at issue. The district court got it wrong by wrongly allowing Mr. Vette's unsubstantiated prisoner complaint allegations without any further evidence to defeat Sergeant Sanders' qualified immunity.
Okay, counsel, let me break in and ask you a quick question here. If we accept the idea that the plaintiff's verified complaint and summary judgment, well, let's just leave it at the verified complaint. The verified complaint was properly considered by the district court. What do you have left?
Your Honor, the verified complaint, even if it was considered, the plaintiff was required to go beyond his pleading, and he did not do that.
Well, we do have authority in this circuit that says we can consider a verified complaint on summary judgment.
Your Honor, that authority also requires that the plaintiff go beyond the pleadings and substantiate his allegations by pointing to specific and admissible evidence in the record, which this plaintiff did not do.
Well, actually, I think you're not really answering Judge Carson's question, because in this circuit, we treat a verified complaint as if it were a declaration. And a declaration is considered evidence that goes beyond the bare allegations of the complaint. So repeating his question, if we think the district court properly considered the allegations of the verified complaint as evidence, meaning testimony from the plaintiff, then what do you have left?
Your Honor, what we have left is that the allegations, those statements in the verified complaint are unsubstantiated.
Well, that goes to weight. So what we have is a declaration that says, I was in custody, no threat to anyone. The officer came up, turned the dog loose on me, and it bit me. And the officer punched me and hit me with a chain. And then we have on the other side various testimony saying that those things didn't happen. So that's a fact question for the jury, isn't it? I mean, you want to argue about the weight. Maybe he's not believable. Maybe your parade of witnesses will bury him in a trial. But at this stage, we don't get to weigh the credibility of the witnesses.
Your Honor, what the district court did and what your question kind of conjectures here is skipping the first part of the summary judgment burden analysis. There's a step 1, which is on the plaintiff, and a step 2. The district court jumped right to step 2 to the weight. What step 1 should entail is requiring the plaintiff to point to admissible evidence in the record that is grounded in the record and also responds to the particularized facts developed by the defendant.
Well, he was there. He was present. It happened to him. They busted me. They got me into custody. I was just sitting there. I wasn't a threat to anyone. And then all of a sudden this officer comes up and he turned the dog loose on me, and the dog bit me. And then the officer hit me, and the officer then hit me with a chain. I mean, then it's your turn, right, to dispute that.
Your Honor, if we adopt this framework that you just proposed, it would eviscerate qualified immunity in cases like this. if a plaintiff can overcome qualified immunity simply by having allegations in a verified complaint with nothing further in the record, then qualified immunity doesn't stand for anything. But this case, this Fifth Circuit's case law is clear, and it's well established that the question of whether these are legal questions and that a plaintiff is required to go beyond the record and demonstrate through evidence.
He can't go beyond the record. You're saying he's got to go beyond the complaint.
Excuse me, go beyond the complaint. Yes.
Okay, so let's explore this a little more. I guess tell me your best case for saying that if the plaintiff lays out exactly what happens, and I think you have to concede that this is basically considered as a declaration. Do you agree with that? Do you concede that his verified complaint under our law is considered to be the same as an affidavit or a declaration given under oath?
Yes, Your Honor, in substance it is. There is a declaration statement on this form.
Okay, so if he says it under oath at summary judgment, I mean, what else does he have to do? I mean, does he have to bring in another witness to corroborate what he said?
Your Honor, there are lots of things that Mr. Vette could do or might be able to do. You asked about the best case, and I would point you to Jordan v. Federal Bureau of Prisons, 191 Federal Appendix 639, and that is cited in the brief. Mr. Vette could take the allegations in his complaint and put it on another form, label it affidavit at the top and notarized at the bottom, but it still wouldn't get to responding to the particularized, consistent, and credible evidence demonstrated by Sergeant Sanders in this case. And then I also want to point out that the verified complaint form that on which Mr. Vette's allegations are stated is the 1983 prisoner complaint form provided in the U.S. District Court for the District of Colorado, that under local rule, every pro se prisoner is required to sign and file.
But not every pro se prisoner declares under oath facts that would support a claim. But in this instance, he did. He said, after I was subdued, they released the dog on me and hit me in the face with a chain and punched me. And Jordan versus Federal Bureau of Prisons, by the way, says, I quote, a verified complaint stating facts admissible in trial and based on personal knowledge has the same force and effect as an affidavit for the purposes of responding in a motion for summary judgment. So I'm not seeing how that's very helpful to you, and it's unpublished. But anyway, the fact that they use a form that gives him help by verifying his complaint so that it can be treated by declaration doesn't change the fact that it is in fact treated as if it were a declaration. So what we have is admissible evidence, his sworn declaration saying these things happen to me. Why isn't that enough?
Your Honor, I would just have to come back to the very high burden that a plaintiff is required by law to overcome in order to defeat qualified immunity. The plaintiff bears this burden, not the defendant. And
so is it fair to say that you're asking us to review the district court's factual determination?
No, Your Honor, I am actually asking
why isn't that precisely what you're asking us to do?
Your Honor, I'm asking you to review how the district court reviewed the facts presented before it and what facts it considered would be submissible to a jury in order to...
Isn't that just a fancy, nuanced, lot of words way of saying that you want us to review the factual determinations of the district court?
No, Your Honor, it is nuanced, but that is not what I'm asking you to do. I'm asking you to review the legal determination by the district court that the allegations in the verified complaint, prisoner complaint, are enough to constitute a universe of facts to demonstrate a constitutional violation capable of overcoming qualified immunity. The district court did not conduct that analysis.
In other words, are you conceding that if we answer that question in the negative, that ends the case, and you're not asking us to look beyond that pure legal determination at what the district court found?
Your Honor,
because if you were appealing for the purpose of asking that pure question, then it seems to me that we just answer that question for you. And as I said, if we answer it in the negative, that's the end of the case.
Your Honor,
excuse me. I hope that's clear, because sometimes I ask a question and people ask me another question. So do you understand the question?
To be honest, not exactly, because I'm not sure.
Let me ask the question as clearly as I can. If we rule against you on the pure legal question that you have just told me exists, is that the end of the case for you at this level?
Your Honor, then it would need to go back to the district court for the district court to reconsider.
I understand. That's not this level.
Yes.
All right. So the answer is yes. That's a pure legal question you ask us to rule.
That is a legal question, Your Honor. Yes.
And all right. Because I was concerned, just so I can tell you my thinking, that what you were really doing is asking us to review the district court's factual determination, and that was our job here, in addition to answering your legal question.
Your Honor, whether there are enough facts in order to demonstrate a violation of a clearly established constitutional right, it's a two-pronged legal question. So, that will involve looking at facts necessarily, but that is a legal question. And the district
but we look at the facts as found by the district court, not sit around here as an appellate court reweighing the factual determination.
Correct, Your Honor.
Thank you.
Let me ask you this. If there
I commend you for your direct answers. Thank you.
If there had been a declaration from a third party who happened to be there at the time that said he was sitting down and wasn't fighting back, the officer came up, let the dog loose, the dog attacked him, and then the officer hit him in the face with the chain and punched him, would that be enough to defeat qualified immunity?
It might, Your Honor. It might not.
How could it possibly not? I mean, you have a third party affidavit, so you've got some evidence that's not coming from the victim, and you have a subdued prisoner who's being attacked by a dog and hit with a chain. Are you telling me that's not clearly established that you cannot hit a subdued prisoner with a chain and sick a dog on him?
Your Honor, that would be at facts going towards a constitutional violation. We don't have that in the record.
Okay, so the only issue here is whether we have that in the record, which means the only issue here is whether we look at the verified complaint and treat it as a declaration.
Your Honor, I would put a nuance on that. The only issue here is whether we look at the verified complaint with nothing further and consider that sufficient to overcome qualified immunity.
Well, my hypothetical, there was nothing further. There was just the declaration of a witness who said, I saw it happen. I mean, what more do you need?
Nothing, Your Honor, but that's not what we're looking at here today.
Well, you have a witness, you just don't like the witness.
Your Honor, that witness is the plaintiff himself, and the case law is clear that he has to go beyond the record and point to specific facts beyond his allegations. And again, if we were to treat this verified prisoner complaint with the allegations that Mr. Vette put in this case, it would undermine and completely undo. It'd be impossible for any person or any defendant to assert qualified immunity and succeed at the summary judgment stage. It would be impossible.
I suppose it depends on what the allegations are. If he said I was fighting the officer and they released the dog and then subdued me during the scuffle, they hit me in the face, we'd look at it and say you're entitled to qualified immunity.
Your Honor, I see my time is nearly expired here for this section. I would just like to conclude by saying the court should reverse the district court and grant summary judgment for Sergeant Sanders on the basis of qualified immunity, because Mr. Vette has not demonstrated the violation of a clearly established constitutional right with his complaint allegations as he's required to do under the law. Thank you.
Thank you, counsel. And just to clarify, Mr. Harone, you set the clock at 15 minutes, did you not?
I did, Judge.
All right. Yeah, so your time is fully expired, counsel. Okay. Thank you. We're ready to hear from your colleague here.
Morning, Your Honors. May it please the court, my name is Ashok Chandran, and I'm here on behalf of the plaintiff, appellee Eric Tyler. And I think, as Your Honor's questioning has made clear, this case, on this record as it exists, is really going to come down to credibility determinations that have to be made by a fact finder. And notwithstanding Sergeant Sanders' efforts to frame this as a legal dispute, I think this court's decision in Pauley versus White pretty squarely forecloses the argument that the universe of facts is a legal determination of the district court. In fact, in that case—
What about the Thomas decision?
Judge McHugh, do you mean Thompson versus Salt Lake County?
I'm sorry, Thompson, not Thomas.
Sure, I think Thompson versus Salt Lake County is not to the contrary. And I think it's the only case that defendants, the appellants really rely on here in support of jurisdiction. But the majority opinion there squarely notes that in resolving qualified immunity appeals, the district court must take the facts as the plaintiff alleges. And Judge Holmes' concurrence, I think, is simply making clear that when a defendant raises qualified immunity, the existence of disputed facts alone doesn't necessarily warrant the denial of summary judgment. Because if even on the plaintiff's version of facts, there isn't a violation of clearly established federal law, excuse me, then summary judgment may still be appropriate. But that's not what we have here. Sergeant Sanders, as I think Your Honor noted, doesn't dispute that if a jury believes Mr. Vette's account, that Sergeant Sanders punched Mr. Vette, hit him in the face with the dog chain, and let the canine dog bite him all after the moment of his apprehension, there would have been a violation of the Fourth Amendment. He just seeks to determine—
Opposing counsel raise a good point. Every pro se prisoner complaint is verified just because of the form. So a petitioner can say, a prisoner can say any full thing they want in a complete evidence. Doesn't that sort of defeat the purpose of qualified immunity?
It's a good question, but I'm glad Your Honor raised it, because I think those concerns are vastly overblown for a number of reasons. First, I think existing rules already screen out frivolous prisoner litigation in a number of ways, including through the PLRA and other procedural bars. But beyond that, I think it's important to look at the unique context of the record that we have here. Sergeant Sanders didn't move on a record like the record that existed in Jordan, which involved deposition testimony, full documents, and numerous witnesses. Sergeant Sanders moved for summary judgment based just on his own testimony. So there may be a case where, and I think this court's precedents are clear, that when a plaintiff relies purely on their own testimony in the face of overwhelming contrary evidence, that's not just the defendant's own testimony, it may not be sufficient to withstand summary judgment. But Sergeant Sanders—
They argue, I'm sorry, that Sergeant Sanders also argues that the photographs are contrary, that if you look at those photographs, it can't be as he described, because when you look at the one where you can see half his face, he doesn't look like he's been hit in the face with a chain, and that the damage to his shoulder is not consistent with what he describes of the dog attack.
Sure, Your Honor. So first, I would note on this point that Sergeant Sanders has waived any argument of the photos blatantly contradicting Mr. Vette's account by not raising it at the district court and not raising it in his opening brief. But I think the argument is also wrong on the law. And that's because, I should say wrong on the facts. And that's because the photograph of Mr. Vette's face that Sergeant Sanders points to only shows, as Your Honor noted, half of his face. And in his response opposing summary judgment, Mr. Vette noted that it's the other half of his face that he was hit on. And Mr. Vette does actually point to other photographs that may exist of this bruising. Beyond that, I think the photographs of the shoulder injuries don't clearly contradict either account. And in fact, if you look at Sergeant Sanders on page A56 of the record, which is his supplemental narrative, states that while the canine made contact with Mr. Vette, it didn't break any skin. But I'll direct Your Honor's attention to page A91, which is the second of 3 photographs that are submitted. And I think that photograph speaks for itself. And you can see that there are marks that could be consistent with a bite. And I think the fact that we're having this conversation is precisely why this needs to go to a fact finder, because those photographs, I think, are subject to reasonable dispute. A jury could look at them and say those 2 puncture wounds seem like they're teeth. That sharp curve might be a jaw. I think it's not the kind of record like in Thomas versus Durasanti or Carabajal or Scott versus Harris. And as Your Honor noted, I think in the previous argument, this is not a case like any other that this circuit has applied the blatant contradiction exception in, because it's just really 2 testimonial accounts.
So, counsel, do you agree that there could be a situation where testimonial accounts were so one-sided that a pro se verified complaint could be held to be not enough because it's blatantly contradicted by the record?
Your Honor, I think that is a question that this circuit has never extended the blatant contradiction exception to. Is there a universe where that could happen? Potentially, but I think it would be a pretty severe burden. And I think Rhodes versus Miller is instructive on this point. That involved 1 pro se prisoner's verified complaint and then 5 officers who were all defendants who submitted affidavits denying that happened. And even though there were 5 affidavits on one side and 1 on the other, this court declined to extend the blatant contradiction exception there. And I think
what if there were 5 affidavits and 2 of them were uninterested third parties?
I think that gets closer to the line of a blatant contradiction, but I still think at the end of the day, Your Honor, where the ultimate resolution of the case is going to turn on credibility determinations, it's likely inappropriate for a court to rule on that. But and I think that's why the Scott versus Harris exception is such a high burden and requires something that is truly incontrovertible, like a video, like a photograph. I think there's one case, maybe it's Carabajal, where there was a photograph of a stoplight that showed clearly that the light was red when the plaintiff ran it. So I think it needs to be something truly incontrovertible, which witness testimony by definition isn't. Now, is there a case where, if you have 100 disinterested parties providing affidavits on one side and the plaintiff alone on the other side? That may be the case, but that's not this case. We just have really 1 and 1. And I think there are reasons why a jury might believe Mr. Vette. There are reasons why a jury might believe Sergeant Sanders. But at this stage, on this interlocutory appeal, it's not the role of this court to second guess that.
Okay.
And I think just one additional point that I would make on the Jordan versus Federal Bureau of Prisons case that Sergeant Sanders relies heavily on here, I think that record is so vastly different than the one that we have here. That was a case involving a pro se prisoner who filed a verified complaint. And then over the course of discovery, when he sat for his own deposition, ended up contradicting several of his own allegations. And then the defendant officers were able to introduce documents showing that the reasons for the deprivations that the plaintiff alleged were all as a result of disciplinary violations or infractions of prison rules, which the plaintiff did not dispute. So on that kind of record, I think this goes to Judge Carson's point, that declarations and testimony of the defendants plus official records can be enough to outweigh a plaintiff's own testimony. So I think for those reasons, it's pretty clear that this case should be dismissed for lack of jurisdiction. And the pure legal question of whether the verified complaint is properly treated as admissible evidence at this stage, I think the answer is squarely yes, as it seems like we all agree. And I'm happy to talk about the merits of the qualified immunity determination, though, again, I think Sergeant Sanders doesn't really dispute that if Mr. Vette's account is to be believed by a jury, there would have been a clear violation of Fourth Amendment law. And that's because I think starting in Perea versus Baca, which is an opinion authored by Judge Lucero, this court has recognized since at least 2011, it's been clearly established that any use of force on someone who's already been arrested violates the Fourth Amendment. And as recently as McCowan versus Morales, this court noted that that doesn't depend on the existence of a prior case involving the specific type of unconstitutional force used, so long as the force takes place after the moment of apprehension. That's all that's needed to establish the violation of law. And that's sufficiently specific under this court's precedents. So the fact that Sergeant Sanders points out the absence of 10th Circuit case law addressing the context of dog bites, I think is immaterial to this calculus.
Well, those cases deal with using a dog to chase somebody down who's fleeing, not somebody who's already subdued, correct?
That's correct. I think the cases that have allowed or denied or granted summary judgment to officers or granted qualified immunity to officers where dogs have been used have involved suspects who are actively resisting or actively fleeing, which, if Mr. Vette's account is credited here, which a jury could do, was just not the case. But I'd also put one further fashion on that even if this court does look for factually analogous situations involving punching, hitting, and using a canine on an already apprehended subject, I think there's really just no argument that as of December 31st, 2017, a reasonable officer could have believed that the Constitution permitted them to do all this. And that's, I think, the Dixon versus Richard case, Caldwell versus Jones are just two of countless examples of this court's precedents finding that punching and striking an already arrested person violates the Fourth Amendment. And although there's not a specific 10th Circuit analog for situations involving dog bites, I think the 9th and 11th Circuit decisions in Mendoza and Priester are instructive, and the unanimity of district court opinions that have applied Mendoza and Priester make it clear that I think it's beyond dispute that a reasonable officer could have thought that they were allowed to behave like this.
And, and all of that's persuasive, and I agree with you, but I do think it makes it very easy for a petitioner or plaintiff to just put whatever they want in their pro se form to defeat qualified immunity.
Your Honor, I understand the concern, and qualified immunity, I think, will continue to operate as a shield, but I think it's important to remember the purpose of qualified immunity is to shield officers in unsettled legal landscapes, not where the facts of an interaction are disputed. If that were true and a dispute over fact could entitle an officer to qualified immunity, then I think essentially every officer would be entitled to qualified immunity in every 1983 case, because the officer in almost every case is going to deny what the plaintiff alleges. And if that alone warrants summary judgment, even if there is clearly established law outlawing what the plaintiff alleges, then no officer is going to be liable for civil rights violations ever. And I think, again, given the numerous other, Sergeant Sanders had the option here to agree to Mr. Vette's facts, or to, in appealing to this court, agree with the district court's determinations that a reasonable juror could credit Mr. Vette's allegations. And if he had done that, he could have appropriately raised the question of qualified immunity on the facts as Mr. Vette alleged. And as we were just discussing, I don't believe that argument would be successful, because I do think it is clearly established that what Sergeant Sanders allegedly did here was a clear violation of the Fourth Amendment. But he could have chose to invoke this court's jurisdiction properly by stipulating to the set of facts that the district court determined could be believed, or stipulating to the plaintiff's version of the facts. And he did neither. And I think it's clear in this argument, he continues to dispute that a reasonable juror could believe Mr. Vette. But I think that under a well-settled precedent of this court is not a permissible exercise of this court's jurisdiction.
Thank you.
So for those reasons, I think unless Your Honors have further questions, we'd submit that this appeal should be dismissed for a lack of jurisdiction, because really every question boils down to—
Thank you for ceding the remainder of your time. We find ourselves in a most unusual situation. A defendant actually ceding time. It's normally the government that does it. Thank you, counsel. We appreciate it. I don't believe there's any time remaining in your corner, Ms. Rowland. So the case is submitted. Counselor excused. And we are ready for the next case as soon as Mr. Haram does the magic wand on us here.
Thank you, Judge. Thank you, counsel. The next case this morning is 20-1151, Wildgrass Oil and Gas versus State of Colorado.
All right, counsel, we are ready to hear you. It's a good day today. We're ready to go.
Good morning, Your Honor.
Thank you.
This is Megan Hayes. I represent the Wildgrass Oil and Gas Committee. I would like to reserve 5 minutes of my time for rebuttal.
Time is yours.
Okay, thank you.
Thank you.
Wildgrass contends that the district court abused its discretion when it invoked a rarely used abstention doctrine to avoid completing a review that it had set in motion. The issue here is whether the Colorado Oil and Gas Conservation Commission's procedure for approving an involuntary pooling application passed muster under the Due Process Clause of the 14th Amendment.
So, counsel, tell me, what about their procedure didn't pass constitutional muster in your mind? Specifically, what did they not allow you to do?
Specifically, and it is alleged in the amended complaint that's in the record on appeal, There are a number of things they weren't allowed to do. They weren't provided sufficient time. I'm not going to go through all those, but well, they weren't allowed sufficient time. They weren't allowed sufficient discovery. I can direct Your Honor to the page in the record in their amended complaint. But the primary issue here is that the commission never articulated the standard on which it would or did decide that its pooling order was just and reasonable, or what terms it would consider to be relevant in the context of this large-scale oil and gas development in close proximity to a residential subdivision.
Let's break that down a little bit. Okay, so insufficient time. Was that a complaint that you could have dealt with in an appeal to state court?
Well, the federal courts are the ultimate arbiters of federal civil rights. And the issue that they have asserted in this as-applied challenge is were they given a meaningful opportunity to be heard for purposes of the 14th Amendment? So sure, the state court could have decided to were they given under the Colorado Constitution, but not whether, this issue that they've raised pursuant to Section 1983 is whether they were meaningfully heard in the context and in these circumstances for purposes of the 14th Amendment.
No, I get that. I guess what I'm trying to get at is, could you have received the same relief in state court through an administrative appeal? I mean, your complaint was we didn't get enough time. I guess the relief you would want from that is for the commission to give you sufficient time.
Right. I don't mean to suggest that we're just whining that we didn't get enough time.
No, I know. I'm planning on walking through the factors with you. Sure. So let's skip the insufficient discovery. I mean, if you wanted discovery, could you have gone to, because one of the important factors under Burford is whether you could have gotten what you wanted from the federal court by going through the state process. And so could you have gone to state court with an administrative appeal and say, look, we were not allowed to put on a case. Their decision was arbitrary and capricious because they didn't consider all the relevant evidence. And, it was, they didn't allow us to put on the things that we thought were important. I mean, could the state court and appeals from the state administrative process have gotten you to the same place for purposes of relief?
No, I don't believe so, and here's why. I mean, the crux of the issue here is, was Wildgrass given sufficient notice of the standard they would be applying? Okay, so yes, we have said Wildgrass didn't get enough time. It didn't get to, do the discovery it wanted. Would it be different relief? The relief Wildgrass is seeking is some clarity on what the standard is that would apply. They're not required to go to state court to get redress for their federal civil rights. A federal court can, and I think it is in the Knopsey decision that, vindication or challenging the constitutionality of state action, the federal constitutionality of state action is the province of the federal courts. And that's what Wildgrass is asking. They had started this federal lawsuit. It was stayed basically while the commission held a hearing. Wildgrass is saying they weren't given sufficient, they had not an insufficient understanding of what standard the commission would be applying to review whether the leases they were offered were reasonable or what it would consider to be relevant lease terms, and how they would determine whether their pooling order was just and reasonable. So
let me interrupt for a minute. What about the commission rule that specifies what they will consider? Doesn't that give you notice of what they're relying on?
Well, as the state has pointed out, those are mandatory factors, yes. There's a fifth catch-all factor, that it has to include just and reasonable terms. I have not seen in either the state's brief or the intervener's brief what that term means. It could mean different things. For example, what sort of lease needs to be offered if this is going to be a large-scale oil and gas development next to a busy rail yard, for example, in proximity to a protected aquifer or riparian area, near a sacred burial ground. I think the fifth term is sort of this catch-all term, so that the commission has the flexibility to tailor to understand whether leases in a particular situation are reasonable. It's not just the Wildgrass members aren't, they're not that worried about whether they're going to get a sufficient royalty or not. They're worried about, are our houses going to be protected? Is our health going to be endangered?
Isn't that just the kind of policy considerations that Burford was faced with and said the federal courts aren't going to get involved with?
No, I don't. Well, I don't think that's the kind of issue Burford was concerned with, because here, Wildgrass has asserted that they have been denied procedural due process. They have been denied the opportunity to be meaningfully heard. It is a federal issue. Most Burford cases don't consider federal issues. There doesn't seem to be any state policy or any rule that fleshes out what this fifth term means. Again, what I'm suggesting is there's no reason a federal court can't make this decision.
So counsel, where would you be if the commission had said, okay, tell us everything you want us to consider, and we're going to consider it? And you said, well, we want to know, is it going to be close to our house? Is it going to cause air problems? Is it going to cause like a sinkhole by our house? And you listed, I don't know what all your terms are, but you asked about all of them. They had a witness up on the stand. You were able to put on your testimony, and the commission said, thank you, Ms. Hayes. Those things don't matter to us. So we're going to rule against you. Where would this case be if they would have done that?
Well, I probably wouldn't be right here at this moment. I might be out skiing or doing something else.
Okay.
But yeah, you're raising an important point. Had the commission provided more clarity about what it would consider to be relevant lease terms, had the commission given Wildgrass members the opportunity to be heard on their concerns about health, safety, environment, financial issues, they would have been heard. But their contention is they weren't heard. And according to the state's brief, there's really no place for them to be heard on these issues in the entire process. And so that's why they've come to the federal court to say, maybe the federal courts should decide, in this situation, did this process comply with the federal constitution, or were we given the opportunity to be meaningfully heard? Did the commission articulate what standards it would be using so that we could address those standards at the hearing and it's Wildgrass's. Had they done what you're suggesting, Judge Carson, yeah, I probably wouldn't be here today.
Okay, so let's talk about this. I mean, you did have an opportunity to be heard, at least on some things. You participated in a hearing and put on 3 witnesses and a certain amount, a little over an hour's worth of testimony, I think I recall from the record.
2 witnesses.
2 witnesses, okay. And at the end, I think you said, hey, I've not had enough time. And they said, okay, how much more time do you need?
Yeah, well, honestly,
I guess, I mean, because it all becomes complicated because you want, then it's, well, no more today because I'm not ready to put on anyone else today. You had to tell me in advance. I guess what I'm wondering is under that catch-all provision, if maybe it was your burden to say what you wanted to say, and they got to decide whether what you said meant something to them or influenced the result.
I'm sorry, I'm not sure I understand your question.
Well, I mean, you want them to tell you, okay, these are the things that are going to be important to us in making our decision. And you say if they don't tell you that, it's a due process violation. And I'm just suggesting maybe as a litigant, it could be your position, your job to put on your case in an effort to advocate and convince them that what you say is important, are important lease terms that they should consider.
Sure. Yeah. Okay. And fair enough. Wildgrass, before the hearing, asked for a minimum of 3 hours, but you know, suggested that it could take much longer than that. Like they had thousands of pages of documents to get through, and shortly before the hearing, they were told, it's on the order of 4 days before the hearing, in a pre-hearing order, final order, they were told they would have an hour and 15 minutes. And so then you have to tailor, I mean, I've got 15 minutes here. I can't, you know, prepare for 3 hours before you all. And then, you know, I'm told I have 15 minutes and all of a sudden, oh, you have more time. Well, I haven't prepared for 3 hours. I've prepared for 15 minutes. I know you'd like to hear from me for 3 hours, but I've got 15 minutes and I'm going to try to tailor what I say to that time. And if at the end of it, you tell me, well, Ms. Hayes, you've got another 2 hours, keep going. I'm really not prepared to do that. So it wasn't.
Well, I hate to be the one who tells you this, but you don't have 2 hours left. You have 40 seconds left. Do you want to reserve time?
I understand.
You told me 5.
For 2 hours. I don't have. I have one issue.
Her time is the remainder of time is reserved. Council will hear from you. I'm pointing to the right of my screen. I don't know who. That's Davenport, I think.
Yes, Judge Lucero. Thank you.
All right.
May it please the court. I am Kyle Davenport. I'm counsel for the state appellee defendants. Counsel for appellee interveners, Mr. David Meschke and I are splitting the argument today. I will explain why Appellant's procedural due process claim is only federal clothing for its mistaken state law arguments that protection of public health and the environment or an operator's financial status are relevant considerations in pooling. And their arguments would also disrupt the Commission and the Colorado legislature's efforts to establish a coherent regulation of oil and gas development, because Appellant's arguments would require the Commission to revisit decisions made at the permitting stage in pooling. I'm also here to answer any questions regarding the Commission's regulatory processes. Mr. Meschke will discuss the application of the Burford abstention doctrine to this case. We just had a lot of discussion about the merits, but the issue presented to this court is narrow, and that is whether Judge Jackson erred in dismissing Appellant's procedural due process claim pursuant to the Burford abstention doctrine.
Well, it's whether he abused his discretion, right?
Yes, Your Honor, thank you. That's a more accurate statement. Judge Jackson recognized after reviewing the Commission's pooling hearing and the motive that state law and policy questions raised by the appellants were best left to the state to resolve. And a really good example of this is Appellant's arguments in regard to Rule 530. That is the rule that provides the 5 factors the commission should consider in pooling. It is the statute that provides the relevant inquiry for the commission in pooling. Section 3460-116-7D of Colorado's Oil and Gas Act provides that when a pooling application is protested, the commission must examine the lease terms offered to the protesting mineral owner to determine they were no less favorable than terms of leases in the prevailing area. Rule 530 that provides that in making that specific determination, the commission will consider 4 specific lease terms and any other lease terms that are relevant to the determination of was the offered lease no less favorable than the leases in the prevailing area. The rule is clear and provides guidance. Appellant's argument is that it was denied due process because the commission did not allow all of its requested discovery or presentation of potential impacts to public health and the environment, history of accidents, or operators' financial condition. That relies on the assumption that these are relevant considerations in pooling. That is a state law question. What are relevant considerations in pooling? And this case also, this state law question also goes far beyond just this case because it goes to how the commission reviews all pooling applications. Finally, this specific question is not one that a state court in Colorado has addressed yet, whether or not those are relevant factors. All of these go to the third element of Burford abstention, state law questions that transcend the case at bar. Similarly, appellant claims a procedural due process violation because it was not allowed discovery into all leases offered or accepted in a 25-mile radius. That is a discovery request that goes outside the bounds of the commission's Rule 530, which allows...
Well, let's assume for the purpose of my question that it didn't go outside. To what extent can these issues be raised in state court?
Judge Lucero, the state court is available through Colorado's APA to provide all of the relief that Wildgrass is requesting.
To what extent does Burford abstention require an exhaustion of state remedies?
Burford abstention does not require an exhaustion of state remedies. Adequate state court review be available, and it is here. The state Colorado APA provides all of the relief that a court may give all of the relief Wildgrass is requesting, including its federal due process.
If that's the case, why isn't this case on your side of the ledger as easy as saying, ladies and gentlemen of the 10th Circuit, here are the Colorado statutes, here's the Colorado Administrative Procedure Act. All of these remedies are available to the appellant in this case. The appellant has failed to utilize, not necessarily exhaust, but utilize these remedies. Thank you, end of case.
But I think it is that simple, Judge, on the one factor of Burford abstention of whether or not timely and adequate state court review is available. As this court knows, there are other elements to Burford abstention, and that is whether or not the case raises...
Well, you're talking about New Orleans public service case?
I am.
Then why isn't your case as simple as saying, 1, there are difficult questions of state law. 2, the exercise of federal review of the question as a case would be disruptive of state efforts. End of discussion.
I think it is that simple, Judge. I may just be taking the long way around of saying exactly that.
It's my problem from where I sit is that cases that might appear to be simple get overly complicated by the arguments that are so far in the ether that I find it difficult to breathe good, clean oxygen to understand them.
I apologize for interrupting.
No, that's all right. Just making a point here.
I understand. I will do my best to simplify. There is also what appellants are requesting is really an entire change, wholesale change to the commission's regulatory process. The commission considers the factors appellants
well,
want
what
to
they're asking is that we throw Burford abstention out the window and by gosh, listen to my arguments and rule on them, right?
That's a much better way of stating what they're asking for than I could have said, Judge.
Okay, well, as I tell my clerks now, then the KISS rule, you remember the KISS rule from
I do.
Kindergarten 101A.
I do, Judge, and in that regard, I will turn the remainder of my argument over to Mr. Meshke.
Well, I don't mean to suggest that I want to rule your way. I'm just saying, I just got to make sure I understand your argument.
I think you understand it very, Judge. I think you understand it very well, Judge. We are arguing that this case meets all of the Burford abstention elements, including that there are state law issues presented, as well as what appellants are requesting is that the court disrupt what is a comprehensive and complex state regulatory process.
Thank you.
Good morning, Your Honors. May it please the court. My name is David Meshke, and I represent the Appellees, the Colorado Oil and Gas Association, and the American Petroleum Institute. As counsel for the state noted, I will be addressing the application of the Burford abstention doctrine, although we've already started that today.
Before you get too far into that, let me ask you this question about it. Give me a case where a court has used Burford abstention to abstain from a federal procedural due process claim.
Your Honor, Burford itself was a 14th Amendment due process claim in a very similar oil and gas context. As the COGCC regulations show, there is a three-step process in Colorado involving spacing, permitting, and pooling. At issue in Burford was the drilling permitting process under a different regulatory scheme in Texas, but it's a similar due process case under the 14th Amendment.
Okay. Since Burford, I mean, Burford's been around a long time. Since that time, can you give me another one? Can you give me a circuit case that's applied it? We've been poking around Westlaw trying to find it, and I just wondered if you could put me there.
Your Honor, as you know, Burford abstention is a very fact-dependent inquiry. And I think one of the cases that is very indicative of what we're dealing with here is the Johnson v. Collins Entertainment case out of the Fourth Circuit. While that isn't a procedural due process case per se, that case involved a RICO statute. The Fourth Circuit indicated very clearly that even though the claim was a federal claim, a claim under RICO, it was really a claim with a predicate state law question. And the court went into great detail on why not addressing that aspect of it, in other words, precluding from Burford abstention all cases involving some type of federal claim, would allow parties to enter into the federal court and disrupt the state court system.
Okay.
Your Honors, we've already addressed the second element under Burford, and really at the heart of this appeal are the third and fourth elements under the NOPSI factors, which are best understood, as counsel for the state noted, based off of what appellant is actually seeking here. The third element is interference with state administrative agency proceedings and orders. And here, appellant's one claim on appeal is not a simple procedural due process claim. Rather, appellant is asking the federal court to determine whether the Wildgrass owners should have been allowed to present evidence at a pooling hearing according to appellant's own view of what that fifth factor in Rule 40 means. And appellant is continuing it was not allowed sufficient time and discovery to present evidence on issues. And looking at the record, those are history of accidents, financial condition of extraction, and the lease terms in a 25 square mile radius that the commission has determined are not topics at a pooling hearing, which is a hearing that is limited to assessing the reasonableness of the lease terms. Therefore, the appellant is really asking for a change in how the commission applies and interprets Rule 530 in the pooling statute, which is broader than whether lease terms offered were reasonable.
So are there stages in the oil and gas development process or progression where the plaintiffs would have been able to air these concerns that I was talking about with Ms. Hayes? You know, the traffic, what it's going to do to the air, the health, safety, and welfare. Is that a situation where they could have addressed those to the commission when somebody was wanting an APD or getting permission to drill?
Yes, Your Honor. So as I mentioned earlier, there's kind of 3 steps in the process. There's spacing, permitting, and then pooling. At the permitting process, health and safety and welfare concerns may be raised in the public comment period.
Well, counsel, we may be sympathetic to the goals that Ms. Hayes is arguing about, the substantive goals. That is to say, if I had a house in a superly nice neighborhood, I might be a little bit upset about having an oil derrick go next by, or smelly pipes, pulling extractions out of the air under my rose bush. But no matter how sympathetic we may be, the state courts and the state administrative agencies are there to air and hear those concerns. So from your perspective, under what scenario would you lose? What burden do you feel that Ms. Hayes could meet that would cause you to lose this case?
Your Honor, this case would be very different if appellants were seeking something else. And I know Appellant has been pointing to the case out of Idaho, Citizens Allied, as a situation that is analogous, even though there's a big factual difference in the fact that in that case, there was no statute or rules determining or helping guide the Idaho's commission on what was just and reasonable. But in a situation where there is a clear requirement under state law that is either isn't followed, or as in Citizens Allied, a situation where there is just no guidance, and as the court's probably aware, the Citizens Allied case, the court actually said this was a close case on the Matthew v. Eldridge factors. But in situations like that, where there's no guidance whatsoever, then there are procedural due process considerations that don't delve into state law and the commission's regulatory processes. But that's not the case we have here.
Let me ask you this. Ms. Hayes argues that to pursue state remedies would have been futile. And they know that it would have been futile because they brought previous actions in state court against the permitting, during the permitting phase, and their arguments were all rejected.
Your Honor, I see my time's almost up. Permission to answer the question?
Yes.
Your Honor, the argument that this would be futile misunderstands not only the APA process. Appellants could, as under the Colorado's APA, appeal a pooling order, just like any other stage of the process, to Colorado State Court, specifically Denver District Court. And then on top of that, this is this is not a futile exercise, because the issue that appellants are actually raising is an issue that is not really supposed to be before this court. It goes to the heart of what this is really about. And so their arguments that this is a futile exercise is based off of what the state is saying, not based off of what a court is saying.
Thank you.
Thank you.
And Your Honor, I see my time's up. I please ask that this court affirm the district court.
Further. Nothing further, Carolyn?
No, thank you.
All right, thank you. Ms. Hayes, thanks to the gracious act of counsel, your opponent having gone over an extra minute, you get an extra minute too. So you've got 1 minute and 34 seconds to finish.
I was hoping I might get my full 3 hours, but I will just go with my last comment, which is that.
Well, I think Judge Carson had only given you 2 hours.
Yeah, in terms of going to state court, yeah, the state has said, and they will argue, that you can't raise environmental health and safety concerns in a pooling order hearing. That's in their brief. It's in my brief where it's cited. And I would just, again, even NOPSI says that federal courts are the ultimate arbiters of federal civil rights and constitutional rights. And the federal court, district court here could have and should have decided whether Wildgrass was afforded due process. Thank you.
Well, it seems to me you're mixing substantive and procedural. I mean, is your complaint a substantive? I thought your complaint was a procedural one, not a substantive one.
Yes, Wildgrass did assert both substantive and procedural due process, but this appeal is just procedural due process, Your Honor.
All right. Just wanted to make sure as I got out of the ether that I got the case right. So, yeah. So it is procedural.
Yes, correct, Your Honor.
Right. You've all been extremely patient with my offhand remarks, particularly Mr. Davenport. Thank you all. I appreciate the argument. My colleagues do as well. Case is submitted. Counselor excused. And Mr. Harone will have you disappear like the ether of the air and call the next case.
Thank you, Judge. The fifth and final case this morning, 20-2028, Vote Solar versus City of Farmington.
Counsel, we're ready to hear you.
Good morning, Your Honors. May it please the court. My name is David Bender for Plaintiff Appellants. I'll try to reserve 3 minutes of my time for rebuttal. Ultimately, the question before the court in this case comes down to whether it is possible to simultaneously violate a federal law and yet implement that law. The district court's decision in this case assumes that it is. However, the plain dictionary meaning of the word implement and every prior judicial decision and FERC order on this topic says otherwise. Implementing.
Well, FERC does too, right?
That's correct. Every court and numerous FERC orders all say that the requirement to implement FERC's rules incorporates both a procedural step one must take and that step has to actually fit within the four corners of the requirements in FERC's rule. Fundamental flaw in the district court's reasoning in this case was its false premise that when Congress provided state and federal courts with jurisdiction over implementation of FERC's rules, Congress intended to bifurcate the procedural piece from the substantive piece. And in applying that false premise, the district court's decision reached a counterintuitive conclusion that Congress gave exclusive authority to state courts to determine what FERC's rules mean and whether they are complied with in substance, and to relegate to the federal courts and to FERC itself a question of policing procedures that happen at the state level. Applying a plain language meaning of what Congress actually said in the relevant statutes and consistent with every other court decision and with FERC's interpretation requires that this court to reject the lower court's premise and reverse. I'd like to briefly discuss how we got here today. The underlying statute, PURPA, Public Utility Regulatory Policies Act, was enacted to encourage utility customers to generate some of their own electricity with renewable resources as an alternative to utility-generated electricity. Technology advances since PURPA was first enacted now allow utility customers, residential customers, small businesses to install cost-effective solar panels on their roofs to offset some of the electricity they'd otherwise purchase from the utility. Foreseeing that utilities would attempt to undermine that type of competition to their monopoly, and the fact that state regulators, at least occasionally, would be unable or unwilling to step in and to stop it, Congress ordered FERC to adopt rules prohibiting discriminatory rates for customers, like customers with solar panels, and requiring utilities sell electricity to customers with solar panels at non-discriminatory rates. And then to ensure that those rules have teeth, Congress gave FERC the authority to enforce, to compel states and unregulated utilities to comply. And Congress authorized utility customers, such as my clients in this case, who have generation to file their own action in district court when FERC fails to act. City of Farmington is not regulated by a state level public utility commission. Instead, the city sets its own rates through city council ordinance. So the city council's periodic ordinance rate setting is the full extent to which Farmington purports to implement FERC's rules. In 2017, Farmington imposed discriminatory charges on customers with solar panels. Plaintiffs, 10 individuals.
Let me stop you. Let me stop you there for a minute. Oh, go ahead, Judge Lucero.
That's all right, Judge Carson. I was just going to say that you said in 2017 something I didn't hear what you said.
So the rate.
In 2017, I was up with you up to that point. I didn't hear what you said.
In 2017, the city of Farmington imposed the rates that discriminate against customers with solar panels.
Thank you. Excuse me, Judge Carson.
Okay, so the word discriminates against customers. That's sort of a legal term of art, right?
Well,
I mean, because I'm wondering. I mean, it seems to be. I mean, the base case here is that you don't like the rates.
Well, I think it's more than that, Judge. It's not that we don't like the rates. It's the rates charge more intentionally, are targeted to charge more specifically to those customers who have their own generation.
Okay. Now, is it ever appropriate in your worldview for a utility or to charge more to someone who's not consistently on the grid and who generates most of their own power? Is that ever okay?
So my worldview aside, FERC's rules say there's a narrow exception, right? So the FERC rules and in the preamble that created them said the assumption is that you charge customers with solar panels the same price for that kilowatt of electricity that you'd charge the neighbor without solar panels. There's an exception which requires the utility to walk through a series of steps, which is do some evidence gathering that has to show that there's a real difference. You have to apply the same essentially cost of service and pricing policies as you design. And you have to make sure that whatever falls out of that would apply equally to another customer with the same usage characteristics, regardless of whether they have the solar panel. So
if I may intervene, Judge Carson, to ask a couple of questions, please. I'm not sure I totally follow what you mean charge more. Let me just understand what you're saying. If Judge Carson and I are customers and you are charging, and we're not on demand meters, we are on a regular meter, and we are paying 8 cents per kilowatt hour. All right, you follow me so far?
I follow so far.
We're both paying the same rate. Now, Judge Carson gets fancy and he buys a solar panel. And he is going to get credits for the amount of power that his solar panel generates, correct?
Not always. I mean, if that's
well, if the sun doesn't shine, he's not going to get credits. But I mean, assuming the panel is generating credits, generating power, he theoretically will get credits against his payments for the power he utilized. Correct? Not so? I guess I don't understand this case because I thought that the issue was whether Judge Carson could be charged more than 8 cents for the kilowatt hour that he uses merely because he is enabling credits to come from his Happy Sunshine solar panel. And that is not, you told me that my understanding is incorrect.
So the analogy would be if you and Judge Carson both use 1 kilowatt of electricity under Farmington's rates, you would each be charged 8 cents for that kilowatt hour. But if Judge Carson has a solar panel, the utility would also slap another charge on his bill for the privilege of having and buying his own and installing his own solar panel.
Well, and I think what Judge Lucero's getting to is whether that difference is offset by the net metering. When Judge Carson's generating his own power from his solar panels, and as I understand the net metering, he's getting some credit for that. Is that somehow offset? I think that's what Judge Lucero was asking. Is there an offset against the extra penny per kilowatt in the hypothetical?
Thank you, Judge McHugh. I was, yes, the question is whether that has the effect of creating a differential rate as between what Judge Carson is paying and what I'm paying.
So that the rate, the utility determines what the rate applies to. So let me back up. The choice of net metering is not proscribed by federal law. So that's a choice that states make on their own and operates like this. You can define a sale of a kilowatt hour based on a time period. And what net metering says is we'll run your meter for the month, and it'll spin forwards and it'll spin backwards, and we'll determine the amount of electricity you are receiving as service at the end of the month.
Right, but you get credit for, so I have solar panels on my home. You get credit when you are pushing out electricity from your solar panels against the bill for when you're taking electricity from the utility. Is that correct?
In some net metering scenarios, depending on the state law or the local law at issue.
Okay, well, how about this? I have my own solar panels on my roof, and I'm pushing power out into the system, and you're having to buy it from me. The ultimate effect is that I'm going to pay you out of my pocket less over time, because you're having to buy electricity from me when I'm not using it all. And sometimes I'm actually buying electricity from you.
Correct.
Okay. Now, okay, so I think that gets us to where we are, what Judge Lucero was talking about.
Well, yeah. Well, meanwhile, Judge Lucero, the energy hog, keeps happily turning on all his power and TVs and electric radiant heating, and I just keep paying 8 cents an hour. What's your squawk? I don't understand. I mean, in simple terms, tell me what's the problem here?
So, well, let me back up. In simple terms, the problem here is...
Instead of telling me what the problem is, you want to back up. Just tell me what the problem is.
The problem in the complaint is regardless of whether you push any electricity out to the grid or not, or whether you consume all of it behind your own meter, you have to pay the utility,
who is you, Carson or me?
Judge Carson, in your hypothetical. The customer with the solar panel has to pay the utility for the privilege of having that solar panel, regardless of how much electricity you use and regardless of whether you Judge Carson.
So what you're telling me is that Farmington is charging a flat fee to Judge Carson for placing a solar panel on his roof.
That is exactly what they are doing. That's in addition to any flat fees that they charge to the non-solar customer.
Now, why does that violate? Why does that violate FERC? And then I'll turn it back to Judge Hugh.
That is an additional charge that no matter what amount of electricity you inflow, right, that you get a bill for, you're going to have your flat charge for your solar panel.
No, I understand. You're saying that practice violates FERC.
That violates FERC's rule, and it violates Congress's instruction not to discriminate, because that is an
Where's the language that it violates? Please, keep it simple for me, because I'm not as swift as my colleagues.
There are two, 18 CFR 292, 303, B. Each electric utility shall sell to any qualifying facility, which includes customer solar panels, in accordance with 305. You go to 305 and it says that rate shall be, it shall not discriminate. And then it has the kind of the exception that we talked about earlier. You can
so you say that precludes charging a flat fee for the privilege of having a panel on your roof.
Right, because the result of the flat fee is no matter how much you use, because of that additional charge, you're paying more for your electricity.
Right, I understand that, but your argument to us is that FERC prohibits charging a fee or flat fee in any event for the privilege of having a solar panel on your roof.
What I'm saying is the FERC rule prohibits a rate that charges a customer with the solar panel more for the electricity that they do receive as compared to the customer with.
Well, that it seems to me is the effect, but it does. All right, I think enough. I'm going to extend additional time because of my questions, but Judge McHugh, you had a question.
Well, getting this back to what we're here on, which is jurisdiction.
Right.
As I understand your position, whether or not the rule adopted by Farmington is discriminatory, therefore violating the FERC rules, is a federal question. And under 210H2B, there's jurisdiction to review whether it was properly implemented in federal court. Is that a correct statement of your position?
I see my time has expired. If I can.
Yes.
You may. You may. I think you may not have heard me, but I said I was going to extend additional time. Go ahead and answer.
Thank you, Your Honor. That is in effect plaintiff's argument here, that the statute providing federal jurisdiction, a federal cause of action, 210H2B, allows the federal court to enforce the requirements of 210F. And there are.
And I think your argument is that Judge Parker's interpretation creates a circuit split in which we would be the Lone Ranger.
Yes, it does create a circuit split with the 1st, 2nd, 5th, 9th, 11th, and the DC circuit on the other side of the split.
Thank you. We'll hear from your colleague here, and then we'll come back to you.
Thank you.
Hello, may it please the court. I am Kristen Connolly McCullough, appearing on behalf of Appellant, the city of Farmington, New Mexico. The only issue on appeal in this case is jurisdiction. It is not whether there can be simultaneous violations of an implementation or the substance of the statute. The district court.
I agree, Mr. McCullough, but sometimes it's really helpful to understand the underlying operation and factual operation in order to place the issue in context, in my defense.
Yes, I agree. The district court here found that there is a venue for the claims alleged by appellant plaintiffs. It just is not in federal court.
But isn't that just contrary to 2010 H2B? I mean, there's overlapping jurisdiction under this statute, and under 210 H2B, you have a federal forum when you're challenging the implementation of the FERC requirements, and you're bringing the action against a utility or a qualified facility, and you are a state regulatory authority or a non-regulated utility. Isn't that what we fall under here? They can bring this action in federal court under the plain language of the statute, can't they?
No, I don't believe that they can, Your Honor.
And and your argument is the reason they can't is because implementation means nothing more than they went through the motions to adopt something, no matter how far that something is from what FERC requires.
Not exactly.
Okay.
So appellant plaintiff's claim here requires a fact-based post-implementation inquiry into how the substantive requirements of PURPA were met. It necessarily questions the data, the assumptions, the calculations, policies, and rate design used by a non-regulated electric utility in developing and adopting its rates for qualifying facilities. Our review, which is consistent with Judge Parker's review in the district court, is that you need to follow the language of the statute. And the language of the statute, if you walk through it, section 210F provides for the procedural aspects and the implementation. Section 210A, B, and C are the substantive requirements, wherein PURPA first requires FERC to prescribe rules for the encouragement of small power production, and where FERC's prescribed rules under A provide for just and reasonable in the public interest and not discriminatory rates for purchases to and from the qualifying facilities from electric utilities. So through subsections A through C of 210, FERC establishes the general guidelines for developing qualifying facility rates, but it does not set the rates itself. And if you look at section 210G, that addresses judicial review and enforcement. And as a plethora of cases have explained, including the U.S. Court of Appeals for the DC Circuit and Portland General Electric, PURPA relies on state adjudication as its mainstay for enforcing PURPA rights.
It does,
federal jurisdiction,
but not its only.
Not its only.
So there's more jurisdiction in the state courts under 210G1 and 210G2, but there's also jurisdiction in the federal courts. And what you are saying is that it's the purview under the statute for the state court to have the final word in what the FERC rules, the federal rules require. And that just seems to turn it on my head, and no other circuit has seen it that way.
So yes, our interpretation of the limited federal jurisdiction described in section 210H is very limited. 210G is very broad, and it cross-references section 2633, which presumes a state court adjudication. Section 210H it explains under H1, it's when FERC has exclusive jurisdiction, and that's when the PURPA rules regard any operations of an electric utility or qualifying facility that falls squarely within FERC's exclusive jurisdiction under the Federal Power Act. But section 210H2 is where FERC is authorized to institute an enforcement action at its discretion if a state regulatory authority or non-regulated electric utility fails to implement FERC's rules. The section notes no other action may be brought by FERC except what's explained in H1 and H2. And
so it's all about the word implement.
It's not necessarily all about the word implement. The Supreme Court has interpreted section 210H and its enforcement authority and has described that a state or non-regulated electric utility implements by doing one of three things: by case-by-case adjudication, instituting a statewide rule, or any means reasonably close to getting the implementation, and that's what's going on here. That the interpretation in FERC versus Mississippi also described the requirements under section 210F, which are what is being enforced under 210H2, as being procedural and only procedural, and it contrasted that with the other sections of the statute. In response, FERC issued a policy statement in 1983 to that Supreme Court case, and adopted and clarified those 3 ways that states can implement and meet the implementation requirement under Section 210F.
Under what the district court did, and under your argument, it seems to me that all the state has to do is make a good faith effort to incorporate the FERC rule, rather than to act consistent with the rule.
And that is, that I disagree with you only insofar as Section 210G is where enforcement with respect to the substance of the rule comes into play. Under Section 210H, we're limited to a procedural inquisition.
And where do you get that you're limited to only whether they went to the motions of adopting something, whatever it might be?
So Section 210F explains that it would be implemented after notice and opportunity for a public hearing. And then the interpretation by the Supreme Court and by FERC shortly thereafter explained that that procedural limitation is appropriate. In that 1983 policy statement by FERC, they specifically...
FERC disagrees with your position on jurisdiction, right?
No, in that 1983 policy statement, FERC explicitly addressed what it interpreted as its role in the statute. And in fact, they said that the enforcements under Section 210H are procedural and gave an explicit example of what it would be to violate the implementation obligation under Section 210F. And it would be if a state or non-regulated electric utility failed to provide notice or an opportunity for public hearing as required under Section 210F. And they said even all other procedural challenges would be directly addressed in the proper judicial forum, not FERC. So those are the only procedural challenges that FERC interpreted within its Section 210H and Section 210F.
Do you agree if we accepted your position, we would be creating a circuit split?
I agree that there will be a circuit split, but I think that one already exists. The cases relied upon that are cited to the DC Circuit Court of Appeals are all taken out of context. Each one of those did not address the jurisdictional issues here. Those addressed whether or not the PURPA enforcement scheme allowed for direct challenges to FERC declaratory orders under PURPA to go directly to the Court of Appeals and bypass the district court. And they found that no, Section 210H claims must go to the district court in the first instance. So those references are taken out of context to rely on the DC Circuit. The Fifth Circuit, and specifically Power Resource Group case, in my opinion, is the first case that actually grappled with this jurisdictional issue after FERC versus Mississippi, the Supreme Court case. And there, the
Fifth... Can I stop you for a minute? I think Judge Lucero dropped off.
Oh.
And so I'm wondering, Judge McHugh, if we should give him a minute to jump back on.
Yeah. Paul, can you see if he's on?
Judges himself and taking himself off camera.
Okay.
Oh, sorry, go ahead.
Go ahead.
Okay, so Power Resources Group, that court grappled with this specific decision. They recognized that the Supreme Court said that an implementation challenge could be limited, and that was a reasonable interpretation, could be limited to the procedural aspects. But Power Resource Group said that they wanted to get to the underlying substance as well, because it was not all of the discretion and the wide latitude that FERC recognized was given to the states under PURPA did not allow for them to essentially cherry pick what it would in fact enforce. And for that reason, that was the first case to actually go into not just the procedural aspects, but expanding the implementation challenge to the substance.
Right. They held that in determining whether it's implemented, it is appropriate to look at whether it was properly or meaningfully implemented.
That's right. And the problem with following that decision, I think, is aptly demonstrated by the subsequent case, excuse me, by the subsequent case and in the Fifth Circuit.
Counsel, do you distinguish in any way the difference between the word implement and promulgate?
In terms of the statute, or in the context of the statute?
In terms of the context of 210 H and F, F states the utilities shall, after notice and opportunity for public hearing, implement FERC rules, not promulgate any rules. And I'm just asking whether, because under the Administrative Procedure Act, the word after notice and hearing is typically followed by promulgate, not implement. There's a difference between promulgating rules and implementing rules. Correct?
I think it depends on the context, but I agree with generally that there might be a difference between those two. I think the concern in following the what the district court here properly characterized as the wrong question, which is in the inquiry, whether it's an implementation versus as applied challenge, the courts are necessarily relying upon whether the claim affects petitioners discretely or categorically. And it's really difficult to implement that. In Exelon Wind in the Fifth Circuit, relying on that power resource case, Exelon Wind, the district court found jurisdiction to hear claims because there was a broad ruling issued in the state order. However, on appeal in the Fifth Circuit, they said that orders were to be treated as applying the rules to the individual petitioners and overturned the district court for the same reasoning in order to find that that the order was an as-applied challenge and fell out and had to be dismissed for lack of subject matter jurisdiction. Just because it's an order with a broad affecting a broad category of plaintiffs, it was still an order being challenged as applied. And with the Fifth Circuit's evolution, the application versus implementation test has turned into an order versus a rule test. And notably, there are courts that did not follow that. The Winding Creek case in the Ninth Circuit found that there was federal jurisdiction over orders limiting qualifying facility rights, which means that they still viewed the orders that the Fifth Circuit would have said are as applied challenges. They still viewed the orders of broad applicability as subject to implementation. Similarly, the Occidental case also found that there would be federal jurisdiction over a review of an order. And so there's already a circuit split. There's this test the implementation as applied cannot be applied easily. The test that we outline follows the statute and is easy to implement and administer, and would alleviate the opening the floodgates into federal court. I see I am out of time. And so for the foregoing reasons, I respectfully request that the court find in favor of the appellee, affirm the opinion of the district court, and deny the appeal.
Thank you, counsel. And I had indicated because of our questions that I would grant additional time to your colleague. Why don't you add a minute and a half, make that 2 minutes total for counsel, and we'll try not to interrupt you, see if we can give you time to finish your argument.
I have a question for him.
Oh, well, I'll tell you what, why don't we add 2 minutes plus the questions from Judge.
Okay, I'll let him go first, then I'll ask my question.
Sure, I'll try to be brief. I would invite the court to read the Mississippi versus FERC case and the Power Resources case and the 1983 policy statement by FERC, because I would submit to the court that none of those support counsel's interpretation that 210H is limited to procedural steps. In fact, I'd point specifically to the 1983 policy statement, which is in Appendix Volume 2 at page 80, where FERC says under 210F, the state authorities and non-regulated utilities are required to implement. And it says under section 210H2, 2A, the commission has the authority to require commencement under subsection F. Then the very next sentence says, moreover, the commission's authority under this subsection extends to situations where the state regulatory authorities or non-regulated electric utilities are alleged to have completed the implementation process, but have promulgated regulations which are inconsistent with or contrary to the commission's regulations. So what FERC actually said was that a case just like this one, where there was an action, but the action violates the substance of FERC's rules, that is a 210F violation, actionable under 210H.
Of course, we don't give Chevron deference to that, do we?
Not to the policy statement, but the court can give Chevron deference to the declaratory orders by FERC, which adopt the same, Cedar Creek being one, Rainbow something, FERC order being another, which apply the same interpretation, in fact, cite it, and those are due Chevron deference.
Sorry, Judge Lucero.
That's all right. We're good. Judge Carson had a question.
Okay, so
under the Lucero rule, we're allowed, Judge Carson is allowed to ask questions, but if they exceed 5 minutes, the gavel comes down.
I hope it's not going to. Okay, so your complaint here is that the city of Farmington basically engaged in a discriminatory charge for small power producers who have solar. And I guess in implementing the rule required by the statute, the city of Farmington had to consider two things. One of them was whether the rates were just and reasonable. That's one of the things they had to be working on, right?
That is an additional criteria in addition to the non-discriminatory.
Right, but yes, no, I agree. And then the next thing they had to do was they had to try to do it in a non-discriminatory way. And yeah, so yeah. At bottom, I mean, had they come up with, had they gone through this process and not decided to ding your clients with a surcharge or whatever you want to call it, we wouldn't be here.
Right. I mean, if there was no discriminatory rate, we wouldn't be here.
I mean, so what you're and their position is well, it's not discriminatory. We calculated that. That was part of the calculation to determine that the rates were fair and reasonable and that they paid for their fair share of the infrastructure and all these different things. And it seems to me that you have a rate case at bottom here. And I mean, you're not suggesting that it's the federal court's job to police all the rates, are you? I mean, that's a state function under this statute.
Right, it's definitely the state function in the first instance to set the rates. And I agree with that. And we only arrive at the federal court if the result is, the FERC rule is thou shalt not discriminate, right? And so, and it says that it adds color to it in the preamble, and we can go to the preamble and go through like, what does that mean in practice? And that I would just submit that's the merits, and I'm happy to get to the merits. We want to get to the merits. The question here is, can we get to the merits? Is that properly before the federal
Judge
court?
Carson's permission, I think we'll close it there with you making an effort to get to the merits.
Yep, I'm all finished. I don't want to get to the merits.
All right. I think if I can summarize the argument is if Judge Carson asks me to jump off a bridge or orders me to jump off a bridge, I either have to make a good faith effort to find the bridge, or if I'm to implement it, I have to jump off the bridge, one or the other. I don't know. That's the case in any event, and it stands submitted. Counsel are excused.
Thank you.
We'll get to the bottom of this and get a decision out for you. Thank you,
Your Honors.
Mr. Harron will announce the recess until tomorrow morning.
Thank you, judges. Thank you.